Let's bring in ABC News Supreme Court contributor and professor at Cardoso School of Law, Kate Shaw, to break this down for us. Kate, the group challenging affirmative action says the 1954 decision, Brown versus Board of Ed, which desegregated America's schools, requires race neutrality. Can you walk us through the legal argument?
Sure thing, Diane. So the group Students for Fair Admissions, which is the plaintiff in both of the cases the court heard yesterday, one against UNC and one against Harvard, basically says that Brown versus Board of Education mandated color blindness in education, that by striking down segregated public schools, right, by ruling that separate but equal was inherently unconstitutional. That's what the court did in 1954 in Brown. And that basically the rule that Brown set forth was a rule that the Constitution doesn't permit any consideration of race. Now, the defendants in this case, the two universities and actually the federal government represented by Biden's Solicitor General, Elizabeth Prelogar, basically said that that argument that Brown mandates no consideration of race here is wrong in basically every respect, that there is a world of difference between mandating segregated public schools precisely in order to subordinate and to subjugate Black school children and to preserve white supremacy is a world apart from modest consideration of race when making admissions decisions at colleges and universities, precisely in order to build diverse classrooms for everyone's benefit. But essentially, those are the two arguments you really heard on display in the 5 hours that the court considered the cases yesterday.
Now, the Biden administration calls affirmative action a national security imperative. If the Supreme Court decides to rule against its use, does the White House have any potential recourse?
Yeah, Diane, that was a very interesting line in the argument yesterday. The Biden administration basically argued, picking up on an argument that got a lot of traction in a 2003 case in which the court upheld affirmative action. Basically, the argument is that the military academies use race-conscious admissions policies precisely in order to build a diverse officer corps that can command a diverse fighting force. We have a diverse military, and military leaders say we need to have diverse officers and diverse military leaders, and that national security compels it. And if we need to use some degree of race consciousness in making admissions decisions in the service academies, then that has to be permitted by the Constitution. And so the federal government really focused on this argument. And so, I think it is possible that the court, I think Terry is exactly right, that the court is likely to rule against Harvard and UNC and against most affirmative action policies in colleges and universities, but it could carve out an exception and basically say, because national security involves presidential prerogatives that are different from the kinds of interests in ordinary colleges and universities, we're not going to prohibit their use in those academies. It could just say we're not addressing that question today. So it could carve it out, but it also could call it into question. And then I think that, there could be a lawsuit that actually presents the question of affirmative action in the service academies. But I think that's something that did seem to give the justices some pause during the arguments.
Now, there was also a lot of debate about the viability of race-neutral alternatives to building diversity on campus. What are some of the proposals being put forward, and do the justices seem to be going for any of them?
That definitely was a theme in the argument. I would say a couple of things. One, some universities and some states have already attempted to adopt race-neutral admissions programs or policies, some of them because they're legally barred under state law from using race. And there have been kind of mixed results. So one example is the University of Michigan, which since 2006 has, as a matter of state constitutional law, prohibited the use of race in admissions. They've tried a lot of race-neutral alternatives, targeted recruiting, sort of big classes, and they've seen a significant decline in diversity, 44% decline in Black undergraduate enrollment, 90% decline in Native American undergraduate enrollment. So some race-blind alternatives have simply not been effective at building really diverse classes, but that may be the future that we're looking at.
All right, Kate Shaw, thank you.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.